Check who is that. It's Yokohama or something. Okay. Yeah, good day, gentlemen. So today we'll have to do another class on the law of evidence. So we're looking at scope of the applicability of opinion evidence. Scope of the applicability of opinion evidence. So before talking about the scope, the first thing we want to talk about here now is what is opinion? What is opinion evidence? Now, when somebody talks about opinion simply means what you think of something or what you think of someone, your views concerning somebody, your views concerning someone. And this, talking about your views may not necessarily be the same thing as the views of another person. So your views may differ from the views of Mr. A or Mr. B on a particular subject matter. And then also, when you also talk about opinion simply means the evaluative judgment of a person. That is your judgment over a particular thing. Maybe you see somebody running away from his, let's say from a scene of crime or so. Your mind may tell you that, hey, this person may be a criminal. This person might have been part of the commission of that very crime. That's why he's running away. That's your opinion. But somebody who has legal knowledge will know that mere running away from scene of crime does not depict complicity. It doesn't mean that the person is guilty of anything. So opinion, every human being can entertain opinion on any subject. I mean, there's a time you see somebody and then maybe you say, this person looks like this, he looks like that. In your mind, intuitively, that's your opinion, what you form. And most of the times, maybe your opinion of that person may be very, very wrong, especially when you get close to the person or you ask some questions, you will discover that what you were believing in your mind about that person is a mere fallacy. It's not true, you know. So when you talk about opinion in the eyes of the law, you're talking about opinion evidence. Opinion evidence simply means the act of somebody coming to court to give evidence on a particular subject matter based on his views, based on his opinion. So in this case, this person giving the opinion evidence is not giving evidence of fact. He is not stating before the court the factual things that happened, but he's simply saying things that he believed that must have happened. So in other words, it's something that is speculative in nature. It's something that is, within what your mind has told you. And most of the times you see the level of education you have acquired will also help in the kind of opinion you form about things. At times we say people in the village, they behave like this, they behave like that. That's your view, that's your opinion, But somebody who is maybe experienced, he has traveled far and wide, his views of life, views of certain things may differ from the views of somebody who has not traveled at all. That's talking about opinion and opinion evidence. Opinion evidence, let's say for instance, the issue at stake is whether Mr. A stole the bicycle of Mr. B. It could be there was no eyewitness and it's just suspicion. And then your own view is that, no, Mr. A is a very good Christian. I don't think he can see this man's bicycle. So what you're saying is mere opinion. It's mere opinion evidence. And then the position of the opinion evidence under the law is that it is inadmissible as a general rule. So we look at section 67 of the Evidence Act to see what the law talks about opinion evidence. Section 67 says the opinion of any person as to the existence or non-existence of a fact in issue or relevant to the fact in issue is inadmissible as a general rule. What you think of what is before the court is irrelevant because the court is interested in the evidence of the eyewitness, direct evidence, or evidence that can be gathered from the circumstance of a given situation, circumstantial evidence. But when you come stating your opinion, you are not there, what you're saying does not represent the truth. It doesn't represent the truth because it's not on the fact. You are simply telling the court what you believe. So section 67 is telling us that such opinion evidence is totally inadmissible, except, which means there are exceptions under the law. Except what? Section 67 says, except as provided in sections 68 to 76 of the Act. So sections 68 to 76 of the Act are the sections that will give us those exceptions, instances where opinion evidence can be admissible under the law. So we'll look at that. But just before then, we want to look at some case laws, how the Supreme Court has looked at what constitutes opinion evidence. So the first case I want to look at here is the case of Oyetola against INEC. Oyetola against INEC. Oyetola against INEC. There the Supreme Court adopted its earlier stand to the following effect that opinion evidence is inadmissible because it is not evidence at all. It is not evidence at all. Neither does it qualify as direct or circumstantial evidence, but it is a mere figment of a person's thoughts. It is a mere figment of a person's thoughts, something that has come from the mind of a person, what a person thinks of a particular situation. And then we also have to know that the rule of exclusion of opinion evidence is purely a common law rule. Under common law, opinion evidence was excluded. It was made inadmissible. It was made inadmissible. And it is an evidence, let me just say, it is just the opinion of the person based on the person's knowledge, not actually on the certainty or the truthful nature of what has happened. Opinion doesn't tell you the truth of that. The person is not even coming from the person's personal knowledge, but we can just call it a suggestion based on the person's views. And then you can imagine where the views of the person is maybe far below your standard. You just look at the person and say, my friend, go away. You understand? Because you feel that his opinion has no value as far as what you are talking about is concerned. And this also is because the opinion is not based on any concrete evidence. It's not based on any concrete evidence. I'm trying to introduce something new now. Opinion, you just say what you want, what you feel. But where there is an evidence and somebody is giving an opinion based on existing evidence, if it falls within the exception, the court will listen to him. But if it does not fall within the exception, then his evidence will be what? It will be worthless. Let me explain further what I mean. If, for instance, somebody tenders a receipt, which on the face of it shows that he made certain payment to Mr. B, and Mr. B is simply denying, I'm not aware, I didn't have anything to do with you. The document you have brought out has nothing to do with me. I didn't sign it. In somebody's opinion, somebody may read it and say, But this document seems to have established that there's a transaction between this person. Opinion. Then if the person is somebody who knows that person's handwriting, the person is, is it not the handwriting of this, my friend? I know his handwriting now. He must be the person who has written it. What am I trying to do? Give opinion based on existing evidence. So two things here, opinion given on non-existing evidence is null and void. It goes to no issue. Opinion given on an existing evidence will now be x-rayed along the purviews of sections 768 to section 68 to section 76. So we're going to take our time to look at them. Now, when you look at, for instance, section 68, it says, when the court has to form an opinion upon a point of foreign law, customary law or custom, or of science or art, or as to identity of handwriting or finger impressions, the opinions upon that point of persons specially skilled in such foreign law, customary law, or custom or science or art, or in questions as to identity of handwriting or finger impressions are admissible. So one thing we take home here is when the court is to form an opinion based on all these things, a court can form opinion on a subject matter in one of the two ways I'm going to mention now. A court may on its own raise an issue, suo motu, and then give parties the opportunity, counsel in the matter, the opportunity to address it on it. Just as happened when the Supreme Court was doing the case of the derivation of from natural resources and all that, what constitutes the EEZ, the exclusive economic zone, and so on and so forth. The court opened it up, address us on this, address us on that. What was the court trying to do? Form an opinion on a particular thing. And then again, somebody may say, like in his case, may bring somebody to give an evidence on any of these areas mentioned here. We are talking about areas of foreign law, customary law, or custom. They are different. Finger impressions, science, and so on and so forth. Somebody may bring somebody to give evidence on this area. What will be the judicial attitude towards that? The judicial attitude towards that kind of evidence is that it has to be given by somebody who is skilled, specially skilled. That's what section 68 talks about. Someone who is specially skilled in that very area. For us to talk about someone who is specially skilled in a particular area, it simply means we are talking about somebody we can, in loose form, regard as who an expert. Somebody who can regard as an expert. So if someone is to give evidence for the court to form his opinion, relying on his own evidence, then that person has to be an expert. Then before we move further, we want to ask ourselves, who is an expert? How is expertise determined? How does the court treat the issue of who qualifies or who does not qualify as an expert? In the case of Attorney General of the Federation against Abubakar, Attorney General of the Federation against Abubakar, the Supreme Court said that an expert is somebody who is specially skilled in the field, in the area of the field that he has come to give evidence. An expert is somebody who is specially skilled in the field, in the area of the field in which he has come to give evidence. In other words, a person qualifies to be an expert if he can speak with some amount of authority. You can speak with some amount of authority on the subject matter, and that authority will come as a result of his special skill in that area, which he might have acquired through training or mastery of that very act or that very area, or familiarity when something is very familiar to you. So three things I pointed out here, and I will begin to look at them one after the other. The first one is that when somebody is spatially skilled by way of training, that basically, or more or less, talk about academic qualification, academic training. You know, when we talk about academic training, it also includes vocational training. So there's that training that will make you to be skillful in a particular act, to be skillful in doing a particular thing. For instance, people who can make baskets, they've made it from time to time, over and over again. So when you come to the act of making baskets, they will tell you the materials needed. They will tell you where how it is done. So as far as the act of making baskets is concerned, that person is an expert in that area because that person is specially trained in that very area. That person is specially trained. Same thing applies to somebody weaving cloth, tailoring. You know why I'm bringing all these areas is for us to know that training doesn't simply mean only when you go to school to learn and get a degree. No, driving too, maybe driving a long vehicle, any kind of vehicle, can give you the competence and give you the skill. And when you have acquired that skill, you become an expert in that very area. And another area we point out here now is about mastery. Mastery simply means what you have done over and over and over again. You know, just like saying that constant training, constant working on something gives you the proficiency. It helps you to master a particular thing, a particular art. So you're a master in that very area. You know, just like maybe somebody who is learning martial arts. You know, maybe at the beginning it may be very difficult and tough for the person. But maybe in the course of time, the person, you know, starts graduating from belt A to belt B to belt C. That is mastery. That's being skilled. And then in that case, that person becomes an expert. Then we also talk about familiarity. Familiarity. You know, when somebody is familiar with something, if I know how you write, and I can tell every time, any day, when I see your write up to say that is this person that wrote this thing, that's when it is said that I am familiar with that particular thing, and that familiarity will be credited to me as what? As an expert in that very area. So expert does not mean jack of all trades and master of none. Expertise could simply be on just a particular subject. So when that subject is an issue before the court, and the court needs to form an opinion on that very issue. Court wants to rely on it, wants to know how did this thing happen, how is it done. So that is when somebody who is socially trained can give evidence, somebody who has a mastery of that area can give evidence, or somebody who is familiar with it can also give evidence. So we'll move from there and look at, first of all, I want to look at the rationale towards admissibility of some opinion evidence. So in other words, the opinion evidence we are talking about here now are either opinion of people who have mastered this, or opinion of people who are specially trained in a particular area to be experts in that very area. In other words, if I have an opinion by way of constant practice, familiarity, mastery, I'm qualified. So if I have gone to university, I go to school and I have my certificate, possibly up to doctorate degree level, then the presumption of knowledge in that area is in my favor. So I'm considered as an expert as far as that very area. Of this one, we're going to be saying the expert who gives evidence as expert per se, and the person whose opinion has fallen within the purview of those opinions that are admissible under the law. He need not to have gone to any university. He need not to have possessed any particular certificate of proficiency in that very area. So we'll go ahead and look at section 69. Section 69. Now, section 69 states, where there is a question as to foreign law, we are taking it one after the other now. Where there is a question as to foreign law, the opinions of experts, the opinions of experts who in their profession are acquainted with such law are admissible. The opinion will be admissible, though such experts may produce to the court books which they declare books of authority upon the foreign law in question, which books the court, having received all necessary explanations from the expert, may construe for itself. Two things we need to know here now. We're talking about foreign law. If the issue of foreign law is a live issue in a case, and there is need for evidence to be given here, the opinion of somebody who is vested in that foreign law will be admissible so long as he qualifies as somebody who knows it, somebody who is an expert. And being an expert here does not mean that he must have been the person who has written the foreign law. No. It must have been somebody who has studied that foreign law. And we can even rely on books of authority, and they explain to them. It's just like the way lawyers cite cases in court. You cite cases, you cite authorities, you didn't write the case, you didn't invite the statutory authorities, but you cite it and read it to the court, just as we're talking about section 69 now. Just an example. So you can rely on books written by those experts to convince the court that a state of being with respect to foreign law do exist or does not exist, does exist or does not exist. But then, after you have said all this, what would the court do? The court does not have to follow it hook, line, and sinker. This provision says, having received all necessary explanations from the experts, the court may construe for itself. The court will just listen to the experts, and then in the end, his own decision. In other words, the expert's evidence is not something the court must adopt automatically. No, it is not automatically binding on the court. This is what this provision is saying. May. The court may decide to rely on it, or the court has a right to still construe it further, find out whether does it apply to the case at hand or does it not apply to the case at hand. They can put on the gem. Does it apply to the case at hand or does it not apply to the case at hand? Now, the import of this very section 69 is that in addition to an expert's personal knowledge of any foreign law in question, such expert shall be at liberty to support his position from authored books. So he can make references. He can make references. Even like, let's say somebody wants to tell us maybe the laws that applies in Barbados. Maybe somebody has brought a document. One of the matters I did some time ago, I think that one was a document procured from Marshall Island, and I raised objection to the fact that that document procured from Marshall Island doesn't show that it's a foreign document, and it was not even certified. You know, so if, for instance, my opponent had wanted to prove otherwise, he could be somebody who is vested in knowledge concerning the laws, the corporate laws of Marshall Island. Because when I looked at the document, I did observe that, quite unlike our own way of notarizing or certifying a document, it didn't do any such feature. It just talked about something like a company, and that was just all. So I was of the view that yes, it could qualify as a certificate there, but here now it cannot qualify as a foreign document because there are things that ought to be done that have not been done. So in that wise, I would have been free to make references to some case laws bordering on corporate practices in Marshall Island. Now let's look at the case of Sona Nigerian Limited. Sona Nigerian Limited. Sona is spelled SONNAR, Nigerian Limited, against Patanri Deri. Patanri Deri, PARTENREDERI. MS Norwind. MS Norwind is a popular case in maritime law. This case is reported in 1985, 3 Nigerian Weekly Law Report, Part 11, page 135. Page 135. Now, in this case, the Court of Appeal held that foreign law can only be proved by calling an expert in that foreign law, by calling an expert who is versed in that foreign law. Maybe an expert who has been, who learned in that country, who acquired maybe a degree in that country, who will give his opinion on it. But that a letter written by solicitors from a foreign country purporting to state that country's foreign law will not amount, purporting to state that country's foreign law will not amount to proof of the foreign law. So let me give us insight into what happened in this very case. That's talking about Sona Nigerian Limited against Patanri Deri, MS Norwind. Now, the issue of foreign law being a maritime case was an issue. And then to prove it, the party who had the onus of proving it simply tendered a letter from possibly a lawyer from that country, anybody, stating that this is the position of the law, just a letter. And the court said no. If you need to prove that, then you have to bring the experts. And we know the effect is that failure to bring that expert means that that document tendered is what? Documentary hearsay. It will amount to documentary hearsay. And one thing we also need to know here now is that foreign law includes all laws that are not made in Nigeria or made by Nigerian legislature. That is foreign law. You can just put it at one. Foreign law means any law that is not made by the legislature of Nigerian government. And well, of course, it also includes received English law. So there's a case I'm looking, an authority I'm looking on that. I'm looking for, okay, that's the case of Funduk. Funduk is spelled Funduk. Funduk against Makoto. Funduk against Makoto. 1995, 4 Supreme Court of Nigerian judgments, that's SCNJ, at page 240. So what this case simply illustrates is that when we talk about foreign laws, we are talking about laws other than laws made by Nigerian legislature. That's what amounts to foreign laws. Then let me also give us another case. That's the case of Bojwani. The case of Bojwani. Bojwani against Bojwani. Bojwani is spelled Bhojwani. Bojwani against Bojwani, reported in 1995, 7 Nigerian Criminal Report, part 407, page 349. In this case, it was held that expert opinion is compulsorily needed. Expert opinion is compulsorily needed when the point to be proved is that on foreign law. When the point to be proved borders on foreign law, then you must bring an expert. You must bring an expert, not to rely on documentary hearsay. This is in order to enable the court decide on such very point. That will enable the court to decide on such point. So, talking about foreign law, we looked at foreign law. Did they check oil out? Talk about foreign law. So the next thing we want to look at here now is section 70. Section 70. Section 70 says, and I just read, in deciding questions of customary law and custom, the opinions of traditional rulers or chiefs or other persons having special knowledge of the customary law and custom, and any book or manuscript recognized as legal authority by people indigenous to the locality in which such law or custom applies are admissible. Custom now. If you want to prove the issue of custom or customary law, either their existence or non-existence of any asserted customary law, the people who are qualified as experts are the traditional rulers, the chiefs, but then they must be people who have knowledge of this customary law. And it's possible to have a traditional ruler who doesn't know the custom. Maybe somebody has just come from the United States because his father was a traditional ruler and the father is late. And the next thing he's selected is coronated. At that point, maybe he's so used to Western life, he doesn't even know the tradition. So that kind of person, if that kind of person should come to court to give evidence, then his evidence would be highly challenged. Because even his people will know that this person doesn't know this custom. So, but it's a different thing when you have a traditional ruler as a doing of the custom of the people, and it comes to court to testify to that effect. And then another way of proving custom, like this provision says, is by relying either on textbook or manuscript. Textbook or manuscript. So from the provision of section 70, the way it is couched, it shows that it's not just enough for somebody to wake up and start writing on the customary law and custom of any locality or any people. Why? Because that thing that he has written must have been acknowledged by those indigenous people as their authority, as their legal authority. So they must just have looked at it and say, yes, this represents our own custom. I'll give an instance. There's this book, I can't remember the author right now. The author was a British. He wrote a Briton. He wrote on the history of my village. Exactly. He wrote on the history of my village. So, but like now we are reviewing it. So we began to see that there are certain things he got wrong, maybe because of the way it was explained to him or from his own observation. But in all, he did nice work, But there are areas you definitely do not agree with him. So when you have a book or a manuscript with this kind of thought, it may be very difficult to push it further to the acceptance level. That this book actually represents a legal authority, except the indigenous people of that very community have already accepted that as representing their customary law. Now, in the case of the Queen ex parte Epenga against Uzogula the second, Queen ex parte Epenga, Epenga, against Ozogula, Ozogula, Zogula the second, reported 1962, All Nigerian Law Report at page 265. At page 265. Ademola CJF as he then was stated, it is of the greatest importance that the native law and custom be strictly proved. It is correct that a custom is not proved by the number of witnesses called, but it is not enough that one who asserts a custom should be the only witness. So this is a different dimension that Honorable Justice Ademola was pointing out there. He said, just like the law is, he was very, very correct on the position of the law. The law does not require that any particular number of witnesses be called to establish a fact in issue in a matter. But when some issues like custom or customary law is to be proved in court, it will not be enough for one person just to come and say it, especially where the other people do not agree. In that way, you discover that such an evidence requires what? Requires corroboration. So you need somebody else to come and say, yes, this is the custom of my people, not one person just coming to say this is the custom of the people. But I think if that custom is given in evidence by the traditional ruler, and then in the absence of anything to the contrary, despite the fact that it is a sole witness, it will be admissible and may be relied upon. Why? Because he is regarded as the custodian of the custom of his people. Now, another case that is important for us to note here is the case of Onwuchekwa against Onwuchekwa. Onwuchekwa against Onwuchekwa, reported 1991, 5 Nigerian Code Law Report, part 194, page 739. In this very case, a book titled The Customary Law Manual 1977 was cited to the trial judge by counsel to the respondent. The judge then used it to find in favor of the respondent on a point of customary law. It was contended by the appellant on appeal that this was not a generally recognized standard work on the custom of that area. Now let's hear what the erudite Nikki Toby, JCA as he was then at that time before his elevation to the Supreme Court, what he said. He said, the law recognizes, and Section 58 of the Evidence Act, that's the Evidence Act that was in practice then, that is the 1958 Evidence Act, which is, in other words, is our section 70 now. So the law recognizes, and section 58 of the Evidence Act says so clearly that in deciding questions of customary law, any book or manuscript recognized by natives as legal authority is relevant. While it is not easy for the court to determine when a book or manuscript is said to be recognized by the natives, the burden is essentially on the party alleging the particular customary law contained in the book or the manuscript. It does not appear from the totality of section 58, that's section 70 now, requirement that the judge can so much to make reference to an existing book or manuscript and make use of it. Section 58 provides 4 levels of evidence. They are: 1. Opinions of native chiefs, opinions of other persons having special knowledge of native law and custom, any book, and any manuscript. I have separated book from manuscript because they do not mean the same thing. So he went further, seeing the opinions of native chiefs and other persons having special knowledge of native law and custom have come from the 2 categories of persons as human beings. The section, in my view, also expects the book or manuscript to be produced by a witness. I say this because it is an evidence relating to the particular customary law, which is recognized as a fact. So things we can take home here, it is just not enough for you to say, Mr. A has written a book on this very area, but you must go further to show the book to the court. After you have produced the book, you also show that this book has been accepted by your people as representing the actual custom of your people. All right, we move from there to section 71. Section 71 talks about facts not otherwise relevant are relevant if they support or are inconsistent with opinions of experts when such opinions are admissible. So I will skip that. 72, when the court has to form an opinion, because it is a prelude to section 72. When the court has to form an opinion as to the person by whom any document was written or signed, the opinion of any person acquainted with the handwriting of the person by whom it is supposed to be written or signed, that it was or was not written or signed by that person, is admissible. This is sub 1 now. Section 72 subsection 1 is talking about identification of handwriting. That when it is an issue whether Mr. A was the person who authored the document before the court, anybody who is acquainted with the handwriting of Mr. A would be competent and will be regarded as an expert in that regard to come and say, I know his handwriting. If I see it, I will recognize it. Then his evidence will be admissible. This type of evidence is usually given in criminal matters where the investigating police officer, the IPO, after investigating a matter, and then the matter is charged in court and he was transferred to another location where he cannot easily be found or be subpoenaed to come to court to give evidence. Then anybody who is vested in the man's signature. So you can compare section 82 of the Evidence Act with that of section 72 subsection 1. Anybody who knows the handwriting of this police officer will come and say, yes, sir, I know his handwriting. He's the one who wrote this. But like I did say during our last lecture, the problem that kind of evidence normally will have was the issue of weight to be attached to that kind of evidence. Why? Because the person identifying may simply not be in a position to answer any question. on that document because he's not the author of the document. He's simply coming to tell the court, I know who wrote this document. I know I'm used to his handwriting. I can identify it. So all he's coming to do, simplicity, is just to identify the handwriting. Now, in the case of Eze Iyamu against Alonge, Eze Iyamu against Alonge is reported 2007, All Federation Weekly Law Report, Part 371 at page 1570. That's Eze Iyamu, Eze Iyamu. It's spelled IZE hyphen IYAMU against Alonge, ALONGE. So I have given you the citation. In this case, the Court of Appeal held that the opinions of handwriting experts are admissible to decipher words beneath obturations, erasures, or alterations, although it is for the court to determine what the words are. Further, the court also held that experts may also give their opinions as to whether a handwriting is natural or imitated and whether it shows points of comparison. But again, it is for the court to determine whether a particular piece of writing is to be assigned to a particular person. It concluded that to determine these issues, documents may be submitted to the court for comparison to be made. Now, there are two things I want to talk about section 72, subsection 1 here now. We're talking about identification of handwriting. And somebody who knows the handwriting, who is not necessarily a forensic expert in handwriting, can be called upon to identify it. And then again, when a handwriting expert is called, that is a forensic expert. The forensic expert will come and tell us whether the stroke is normally called stroke, that's the handwriting, whether the stroke of this person is actually that of the person being pointed at. In other words, most of the time there will be like two documents to do the comparison. They will just see how the person writes his R, how he writes his Y, how he does his A, Z, and so on and so forth, and subject it to forensic analysis to be able to show whether a particular write-up is written by the same person, or whether somebody imitated the handwriting of the person. Why? Because even if you're imitating the handwriting of a person, before you do a full line, you will fall out. There's no way. It's not very possible to imitate somebody's handwriting to do some few lines. So experts will tell you that. So when the experts come to give such evidence, they can give evidence and go. But the evidence is not 100% binding on the court. Why? Because the court will also have the right to do what? Look at the two writings to know whether, in comparing them, that they will believe that it was actually A that made the document, or it was not A that made the document. So experts will come and give your own evidence and go, and then in the end, the court will do its work. So this is what this very provision and the case of Eze Iyamu, a lost race, And at times you may even ask yourself, why is it that the court cannot, 100% believe in the evidence of an expert? It's possible that an expert could be hired, paid, as a commercial person to come and testify for one person. So that prejudice, the likelihood of prejudice must be taken into consideration by the court. So that will be like a caveat, a caution for court not to be in a haste to believe everything that has been said by the expert, but to also make his own comparisons to know whether it will believe and rely on the expert evidence or not. So we look at subsection 2. It says a person is said to be acquainted with the handwriting of another person when he has seen that person write, or when he has received documents purporting to be written by that person in answer to documents written by himself or under the authority and addressed to that person, or when in the ordinary course of business documents purporting to be written by that person have been habitually submitted to. You can see about 3 or 4 levels here now. In other words, this tells you how to ascertain if the person who has claimed to be acquainted with a signature of this handwriting actually would be believed in that circumstance. In other words, this is the foundation. The foundation it has to lay is that it has to give us instances that brought him into seeing his handwriting. Do they have correspondences in the past? Somebody who has correspondences with you in the past. It could be possible that once you see his letter, those days that one writes in longhand. You see his letter written in longhand or document, you say, yes, it is this person. Or could it be you have worked with the person in an establishment and you are so versed with his writing that once you see it, you recognize it? Or is it that maybe he habitually exchanges, that kind of correspondences with you? Or have you worked under any authority, like we have said, or in the course of business, he writes and you see his writing, and once you see the writing, you know exactly this is the writing of this my friend. So from there, we move to section 73. Section 73 says when the court has to form an opinion as to the existence of any general custom or right, the opinions as to the existence of such custom or right, or persons who would be likely to know of its existence if it existed are admissible. Sub 2 says the expression general custom or right includes customs or rights common to any considerable class of persons, custom or right. The other one, we talked about customary law, but this one now is just an incident. It's talking about customs or rights. If, for instance, when somebody dies in a community, customarily he will be entitled to be buried or given a befitting burial. What and what would amount to befitting burial would be given in evidence by those who know, those who have practiced over time. So anybody with such knowledge can give such evidence, and it will be admissible under this very section that we're talking about. And again, to let's say, for instance, under Ngwa customary law, the right of maybe when you buy purchase a piece of land from an Ngwa person, there are things you may need to do. For instance, the introduction, the what they call change of ownership, Idori Huogon, and so on and so forth. They may want you to come and do those things. And assuming I'm not an Ungwa person and I bought the land and they have confronted me with all these things. And I'm like, well, I bought this land. Why would you want me to spend about 2-3 million naira over this again? So if, for instance, the matter goes to court, they can bring anybody who is knowledgeable in that very custom and the rights, to come and give evidence that yes, under their law, that this actually is obtainable. So we'll quickly look at the remaining provision. Section 74. When the court has to form an opinion as to the usages and tenets of any body of men or family, or the constitution and government of any religious or charitable foundation, or the meaning of words or terms used in particular districts, or by classes, particular classes of people, The opinions of persons having special knowledge on the matter specified in this section are admissible. So this one is just have it has a relationship with custom. It's talking about usages and tenets. Usages and tenets can be maybe an incident of trade, an incident of commercial transaction. For instance, in this jurisdiction, there's something we call a buffer here. Somebody who doesn't have maybe even a store where he sells goods. You see somebody coming around, he rushes to the person, what do you want to buy? And the person says, I want to buy a laptop. He takes the person to where laptop is sold. So in that wise, he is acting as an agent to the person who is selling the laptop. And the person sells. If it is the practice that he'll be given something as a good boss here, normally they will top it to the purchase price. So when that happens, the person will be entitled to that. So if maybe somebody has done the boss here now, and he's finding it difficult to recover his money, and there is a litigation or there is an issue as to whether or not he's entitled to the money added, he can lay in evidence, bring anybody who is used to the usages and tenets of such commercial transaction to come and give evidence and say, yes, this person is entitled to receive money as somebody who has done the Ebosa here. Then section 75. When the court has to form an opinion as to the relationship of one person to another, the person expressed by conduct as to the existence of such relationship of any person who, as a member of the family or otherwise, has special means of knowledge on the subject is admissible, provided that such opinion shall not be sufficient to prove a marriage in proceedings for a divorce or in a petition for damages against an adulterer or in a prosecution for bigamy. I will take this provision again. It's talking about relationship. If somebody knows that Mr. A, who has suddenly come to the compound to say that Mr. Z was my father, Mr. Z is no longer living, and is telling Mr. Z to be his father. Anybody who knows, or maybe who Mr. Z told in his lifetime, look, I have an extramarital affair and it resulted into a child. Anytime you see the child, you know he's my replica, please accept him. Such a person with such knowledge can give evidence, yes, this child belonged to Mr. Z because he has knowledge. In that type of knowledge may be if, for instance, he knew about the relationship between Mr. Z and the child's mother to an extent when the child was conceived and born. That is knowledge. Another form of knowledge could be Mr. Z telling him, look, my friend, I have a child, and in case anything happens to me and this child comes back home, please help me, let my people accept him as my child. And then at times too, you could have a relation, maybe he wants to go and get married in a particular family. And then another man comes, an elderly man, no, 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 you don't do that. It will be a taboo. And then you start narrating how your grandfather is related to their great great grandmother. What is he trying to do? Establish a relationship. Such evidence is admissible. But then, such evidence cannot be used to establish a marriage in a divorce proceeding or to establish the offense of bigamy against the person that had already done that. So it only exists to show that there is a relationship and nothing more. And then finally, we look at section 76. Whenever the opinion of any living person is admissible, the grounds on which such opinion is based are also admissible. Whenever the opinion of any living, maybe most of the times, something will be happening in the village and the issue will be, who is the eldest man in this village? and then the person will be mentioned. People will go to him. Please tell us a story about this. Even for instance, a student that you are writing a project that has to do with custom of a particular people, and then you go to the elderly man who knows the story, he can tell you. Such assuming such evidence is required in court. So the opinion of such person, in as much as he didn't go to school to read it, will also be what? Admissible. Now, when we look at all these sections that we have looked at, it has not delved into sciences. So what it did was to mention sciences ab initio at the earlier provision, that is talking about section 68. So when you talk about science, it's a very wide range area. It's a wide discipline. So the Evidence Act has not bothered to go into science bit by bit. For instance, medical history, and DNA and so on and so forth. It has not done that. But it does not mean that anybody where the issue is for the court to form opinion whether A was the child of Mr. B, and then you're talking about science now. An expert says, let's subject them to DNA test. The test is run, and then he gives his views, his opinions. It becomes evidence of an expert, and it becomes what? Admissible. And maybe somebody dies, and then an autopsy is conducted to find out the cause of the death of the person. What are we talking about? Science. So anybody who has conducted the autopsy can come to court to give evidence as what? Somebody who has special skill, knowledge in science. This evidence will be admissible. And then again, when you have a team of medical doctors treating somebody or doing surgery, each of them can give evidence on what has happened, irrespective of the fact that one person wrote the medical report, because the whole of them can't just join hands to write the medical report. One person has to do it. But anybody that participated in that very exercise becomes an expert and is competent to give evidence in that very regard. So far, so good. We have come to the end of our today's lecture. Thank you for staying tuned. I will inform you when next we treat yet another topic. Thank you.